Hello, everyone, and welcome to another live edition of Employment Law Q&A. My name is Alex Lucifero. I am an employment lawyer and partner with Samfir Tumarkin LLP. We are the employment lawyers, and this is a live Q&A. We are here to take any and all questions related to really any issues that you're dealing with at work. If you are an employee tuning in right now and you're dealing with a situation at work, maybe your boss isn't treating you fairly. Maybe they're bullying you or treating you in a way that you feel is inappropriate. Maybe you've been let go from your job. You've been restructured out of your position. Maybe you've been let go and it's alleged that you lacked performance or perhaps some sort of misconduct allegations. Or maybe you're dealing with changes in your workplace. Maybe your employer has asked you to change your compensation package, or to accept a demotion, or perhaps even to accept lesser hours at work, or even a temporary layoff. Any of these kinds of situations, again, if you're dealing with perhaps a bad boss, if you're dealing with a termination, if you're dealing with a major change at work, all of these kinds of situations trigger your rights as an employee in Canada and specifically in Ontario. And these are situations, and this is crucial for everybody tuning in. These are situations where you absolutely have to receive advice from an employment lawyer. If you are dealing with a difficult situation at work and you don't know what to do not assume that your employer is doing what is best for you. Do not assume that your employer is doing the right thing necessarily. It is the reality of business that employers are going to look out for themselves. They are going to look out for their bottom lines. And perhaps in third place in that order of things, they may look out for their employees. But certainly when it comes to changes in the workplace, when it comes to potentially mistreating employees, and certainly when it comes to severance, employers will almost always offer employees far less in terms of severance than what they are actually owed. Again, your employer is looking out for their own best interest. You need someone in your corner as an employee who is going to look out for your best interests as an individual, as an employee. This is exactly what we are here to talk about over the course of the next half an hour. How do you, as an employee, protect your rights, protect what options you have, and maximize the leverage that you have as an employee in your relationship with your employer, whether that comes within the employment relationship during the course of your employment, maybe even at the start of your employment with a contract negotiation, and also certainly when it comes to the end of your employment and a termination. How do you maximize your severance entitlements and protect your own interests and really give you that financial compensation that you are going to need to hold yourself over until you can find that next job? That's exactly what we're here to discuss over the course of the next half hour. So please, if you're tuning in right now, maybe you're dealing with a situation at work, and maybe you're worried about a potential situation at work. Listen, do not be shy. Go ahead and post your question right now on whatever platform it is you're tuning in on. You don't have to provide your name. You don't have to provide your employer's name, certainly. Keep everything brief. Keep everything confidential. Give us a generic question, and I promise I will get to your question over the course of the live Q&A. This is what we're here to do. We're here to answer anyone's questions. If you're dealing with concerns and worries and issues at work, we are here to get you on the road to addressing those concerns and solving those workplace problems. Before we get into the mix here, I want to share our contact information because, and we hear this all the time, either through email or in private messages. There are certainly some of you who might be a little too shy to ask a question online or through whatever platform you're viewing on. And so you want to contact us in the office outside of these kinds of streams. Listen, that's absolutely okay. There's no pressure to do so. The first place you probably want to visit is our website, employmentlawyer.ca. Employmentlawyer.ca. You see it on the screen right now. Again, it's a great starting point. Of course, all of our contact information is on our website. Even better than that, we've got a ton of resources on the website. Articles, news clippings, lots of videos, and lots of employment law essentials and primers, where if you're looking to kind of classify the problem that you're dealing with just in a very basic preliminary way, we've got a bunch of articles there that you can break down. If you're dealing with a termination, what to do. If you're dealing with a temporary layoff, what to do. If you're dealing with changes in your workplace, what are your options and what you should be doing. Go ahead and visit our website for that reason, and also for our contact information. Even easier than that, quite frankly, listen, email us. Do not be shy at all. There is absolutely no cost involved. It is all completely confidential. Send an email to help@employmentlawyer.ca, and I promise someone will get back to you if you email us there. Give us a brief description of the situation that you're dealing with. Give us the basics of what we need to know. Please don't send us a 10-page a letter with every single incident that's ever happened in your workplace. That might be overkill. But again, send us a brief description of your situation. And again, we've got an entire staff of intake personnel standing by to field calls, field emails, and of course, answer any questions and put you in touch with one of our experienced employment lawyers. Those are ideal ways to contact us online, of course. And we love the old school phone call as well. So do not be shy. If you're in Ontario, Canada, if you're in British Columbia, or if you're in Calgary or Alberta more generally, go ahead and give us a call at the office. Do not be shy. We can post the number over the course of today's live Q&A, and you can mark that number down. Again, it's on our website as well. Don't be shy to just give us a call at the office. And again, we have an entire team standing by to take your calls. And of course, if you get our answering machine, go ahead and leave us a message. Again, someone will get back to you, I assure you. Once again, for those of you just tuning in, this is a live Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin LLP. We are the employment lawyers in Canada, and particularly in British Columbia, Alberta, and Ontario. If you are in any one of those provinces and you are dealing with a situation at work and you don't know what to do, and your employer might be strong-arming you into a certain position, a certain answer that they might want you to give, do yourself a favor, buy yourself some time, give us a call, and let's have a conversation. I guarantee you have way more rights as an employee than what you think you have. There are lots of legalities, mechanisms, options that you as an employee have when you're dealing with your employer and when you're dealing with difficult situations at work. But of course, the law can't help you. Those options can't help you if you don't know the way the law works, if you don't know what those options are. That is what we are here to do, to explore those options with you and to ultimately give you advice on what your best option is, on what you should be doing in response to a termination, in response to a change at work, in response to your employer mistreating you or accusing you of something. Again, you need employment advice in those situations. I typically always start these live Q&As with a bit of a what we call, at least on our radio show that airs across the country as well, a segment called the Case of the Day. So it's an opportunity to talk about a matter that came across my desk and that I think is a good example of situations that lots of employees across the country are dealing with within the context of their employment. A bit of a different one today, and I'll be brief about this because I want to get to the questions. And again, for those of you tuning in, go ahead and post a question right now. It could be very generic. If you're curious about something, go ahead and post the question. Or if you're dealing individually, or maybe your spouse, or maybe a friend or a family member is dealing with a situation at work, please go ahead and post the question. Absolutely free. You're going to get an answer from an employment lawyer. Keep it confidential. You don't have to include your name. You don't have to include your employer's or the employer's name. So feel free to post the question right now. I'm going to get to it in a couple of minutes. But I did want to talk about one particular matter that's come up in the news this week and that we are seeing lots of over the course of this year. And I would say the past several years in particular. And that is when a business is bought and sold. So we are dealing with lots of employers, particularly Ontario, but again, this applies across the country, across any province really that you're dealing with. Listen, there are lots of corporate restructurings happening. There are lots of mergers, as they're called, lots of companies being bought by other companies. And in any one of these situations, when there's a merger, when there's the sale of a business or the purchase of a business, employees are going to be affected. There's absolutely no doubt about it. Lots of times when it comes to a merger, for example, when two companies are combining, it's unfortunately the case that employees are going to be let go in that situation. There's going to be a certain amount of collateral damages that comes out of those corporate transactions, and the collateral damage is employees losing their jobs. Unfortunately, same thing happens when a company is bought. Lots of times, new ownership, new management will come into an employer and say, "Hey, we want to do things our way. We want to do things a different way." And unfortunately, particularly for management level employees, I will say, unfortunately, a lot of times what that means is that the new ownership group will clean house, clean management, clean the executive level of the company, and maybe even supervisors and more senior, longer term employees. And they will then hire their own staff, their own picks for those positions, being new owners in the company. I want to make two particular points here. If you're dealing with a situation at work where your company is being merged with another company, or perhaps your company is being bought, or maybe your company is buying another company, any one of those situations, the law applies in this particular way. If your employment is affected by a merger or by the purchase and sale of a business, keep in mind, number one, and most importantly, you have every right as an employee to every protection under the law that any other employee would have in any other circumstance. The law does not change when it comes to severance, when it comes to temporary layoffs, when it comes to changes to your employment, which an employer is not allowed to make without the employee's consent. Nothing changes just because a merger is happening. Nothing changes because the company is being bought or is being sold. You, as an employee, have the right to stand up for all of the rights you would ordinarily have in the circumstances, regardless of what the company is deciding to do with the business. Now, of course, when we're dealing with a termination, so let's say your employer is merging with another employer, and that means that your job is coming to an end. You've been notified that you're being let go from your job because of that merger and that restructuring. You would be owed severance, of course. Severance is going to, again, it's going to operate in the same way as if the merger didn't happen. Severance is going to be based on your age, your position within the company, and your length of service with the employer. Length of service is going to become an important point I want to make when it comes to mergers and purchases and sales of businesses. But again, severance works the exact same way. It's based on your age, position, and years of service. The older you are, the more senior you are within the company, the more senior your position is, and the longer you've been with that company, the more severance you are going to get. Severance is not a week or two per year of service or a week or two full stop. Severance could be as much as 24, that's 2 years of pay, particularly for longer service employees, for older employees, for management level employees. You could be looking at as much as 2 years of pay when it comes to your severance entitlements. And again, that's regardless of the reason for termination, whether it's a merger or whether it's any other reason for the termination. Now, when it comes to length of service, again, if your company is being bought and sold, or if your employer is merging with another company, keep in mind that when that sale happens, when that merger happens, you don't start obviously as a day one employee just because the company changes. Maybe the name on your paycheck changes. Of course not. All of your previous years of service with your previous employer continue to count. In other words, you carry over your years of service with the previous company onto your, I guess you can call it new employment with the company that's now taken over, the new company that's emerged out of the merger. So previous years of service count, and they continue to count. You don't lose that tenure when you continue on with a new company that's just bought your employer or through a merger. Extremely important, because you could be a 20-year employee, and if there's the sale of a business there, again, you don't become a day one employee when that happens. You carry over those 20 years of service. So if the new employer decides to let you go, they owe you severance based on that entire 20 years of service. They don't owe you severance, of course, as a day one or day two or week one or week two or year one employee. Right? So keep in mind, when it comes to length of employment, when we're talking about the purchase and sale of a business, your previous length of employment, your previous term of employment carries over to the new employment, to the new company or the new owners, if we can put it that way. Last point I'll make in this respect. Do be very careful as an employee when you're dealing with a merger or you're dealing the purchase and sale of your employer and you're changing ownership as a company. It is often a point in time where employers want to introduce employment contracts for these employees. And so a lot of times the purchasing company will come in and say, hey, we'd like to continue on with the new company. We're buying your employer. We'd like you to continue your employment. Here's a new employment contract. Listen, that's great. Of course, you want to continue your employment in over the context of a purchase or a merger. However, a lot of times those employment contracts have terms that are significantly different to the terms of your employment that you currently have. And by different, I mean different in a negative way. A lot of times those employment contracts will have termination clauses, termination provisions, as we call them, that limit your severance entitlements. A lot of times those new contracts will have language that allow the company to temporarily lay you off or allow the company to make different changes to your employment without your consent. Be very careful. And actually, I'll apply this more generally to any employment contracts that you're signing as a new employee or even as an existing employee of the company. Be very careful about what you sign when your employer is presenting you with a new contract. Look at pages. Fine. Page 1 and page 2 will have the important items. What's your salary? What are your hours? What are your benefits? What are your bonuses? All of that. What are your vacation entitlements? Listen, don't get me wrong. All of that stuff is important, right? It's the key stuff when it comes to a position. But look at page 3. Look at page 4 of that contract. You'll oftentimes see language about termination, language about changes to your employment, language about temporary layoffs. And those things could matter just as much in the long term than what your salary might be with the company or what your position might be with the company. Take a look at the details. And if you don't understand what they are, and certainly if those new contracts are different to your previous terms of employment, have a look at your old contract. And if that termination language wasn't in your old contract, right, that's a problem. That's going to be a big issue. Before you sign that employment contract, make sure you give us a call and get advice from an employment lawyer. There are ways in which you can protect your rights as an employee in the context of a purchase and sale of a business, in the context of a merger. Don't just blindly sign off on any kind of employment offer without getting advice first, because if you sign a contract that has enforceable termination language, you can be leaving tens and tens and tens, and I'm not exaggerating here, even hundreds of thousands of dollars on the table from a severance perspective, as compared to if you did sign that, or if you didn't rather sign that contract. There's a big difference between an employment contract that limits your severance entitlements and severance being based on your age, position, and years of service. You want to be in that category where you can calculate your severance entitlements based on those factors. And if there's a contract in play that limits your severance, you might be stuck to what's in that contract. All right, everyone. Thank you so much. I wanted to go through that because I am sure, I have no doubt that a few of you listening right now, right? Or again, maybe you have a family member, maybe you have a friend, maybe you have a colleague who is dealing with exactly this kind of situation, who's dealing with a merger at work, who's dealing with the purchase and sale of a business, and they have absolutely no idea what to do. They don't know whether their job's going to be around or not. They don't know if they sign that new contract, what's going to happen. Be aware of these issues, and your default response should be, you know what? Let's give Alex a call. Let's give Samfir Tumarkin LLP a call. Let's have a chat about what options I have, what I should be doing in this situation before I commit in writing, before I sign on the dotted line, whatever that dotted line might be. All right, guys, let's get to the questions. Thank you all so much for your patience. First in line this afternoon was a question on YouTube from Damon. Damon asks, when reviewing an employment contract, should you be on the lookout? What should you be on the lookout for so you can protect your rights? Damon, I didn't see your question, quite frankly, before I just went into my little rant there about employment contracts in the context of purchase and sales of a business. But luckily, I answered the question for you, because really, whether we're talking about a merger or whether we're talking about a position that you applied for, that you interviewed for, and you've now received a job offer. By the way, that's great news. Everybody wants to be in that situation, and it's great to have an offer of employment, particularly nowadays. It's not easy to find the right job. What you should be looking out for, Damon, are the factors that I just mentioned when I was speaking a couple of minutes ago. In addition, of course, to what the salary is going to be and what the position is going to be, and your vacation and your benefits and all of that crucial stuff, you want to look out for language about termination and severance. You want to look out for language around temporary layoffs or around the employer being allowed to make changes to your employment. If you spot any of that kind of language, you want to get on the phone to an employment lawyer right away. Give us a call, send us an email at help@employmentlawyer.ca. Honestly, your email could be, I have an employment contract that I'd like to review with someone. Can I please schedule a quick call? Happy to do that for you. We enjoy reviewing employment contracts because, it's obviously a positive thing, right? You receive the job offer. That's great. A lot of times these job offers are negotiable, particularly because we know that the employer wants you and has offered you the position. They're oftentimes going to be a little flexible in the contracts that they offer, particularly around those kinds of points. So don't be shy to have a conversation, number one, with us, and then secondly, with your prospective employer about the job offer that you received. A lot of times, those kinds of terms are negotiable. So, Damon, keep an eye out for that kind of stuff. Again, it's the stuff that's not going to be on page 1 of an offer letter. It's going to be on page 2 or 3 or 4 or 5, maybe even 6, 7, or 8. Right? But that stuff is just going to be just as important in the long run and just as enforceable as whatever your salary is going to be on that contract. All right, question on Facebook from Christian. Christian asks, can my supervisor force me or demand that I do a completely new duty or responsibility that I wasn't hired to do initially? Christian, very interesting question. And I guess the answer is it depends. It depends on how completely new or I guess unrelated this duty is. We could think of kind of extreme examples here on both sides of the spectrum. So, for example, if you were hired as let's just say, for example, an IT technician, Christian, and the completely new duty that you're being asked to do is related to IT, but you've never done it before. I don't think there's anything necessarily wrong with that. You may want to tell your employer, by the way, hey, by the way, I've never done this before. I know it's kind of within the context of IT, but it's not something I have experience with. I'm going to need some coaching, or I'm going to need some training, or I'm going to need some patience from you as I learn what to do with respect to this new task. But again, I give this example in the context of something that's within the wheelhouse of the position that you were hired for. Right now, that's kind of the easy example. The more difficult example, Christian, and also I have to say the example where your employment rights as an employee will be triggered is if you were hired as an IT person, right? But your employer then tells you, hey, by the way, I want you to also clean the washrooms at work. You're going to have to mop the floors and clean the toilets and clean the sinks, right? Well, listen, that is not within the wheelhouse of what you were hired as an IT technician. It is something that is completely new and also, perhaps more importantly than new, completely out of your wheelhouse. Right. And so in that case, you have every right as an employee to say, no, I'm sorry, that's not part of my job description. That's not part of what an IT technician should be doing. Right. I'm not a janitor. I'm not in maintenance. I was hired to do other kind of work. Thanks, but no thanks. You would have every right, Christian, as an employee in that situation, to take a stand and say, no, I'm sorry, that's not a task, it's not a job responsibility that I'm prepared to accept. If your employer, threatens to fire you over that, or says that, well, if you don't do that, then we're going to assume that you quit your job. That is what we call a constructive dismissal. A constructive dismissal is basically a breach of contract. It's when your employer no longer plays by the rules of the game or the rules of your employment and makes a major change to that employment. And of course, asking you to clean the washrooms when you're an IT person is going to be a major change to your job responsibilities and duties that would trigger a constructive dismissal. So hopefully that helps frame the issue, Christian. Again, if it's something that generally speaking in your position, while you've never done it before and therefore it's new, you might be expected to do, listen, you may have to bite the bullet and do it, even though you've never done it before. If it's something completely out of your wheelhouse, I'll give you another, maybe more common example. If you're a salesperson and all of a sudden, out of nowhere, you're asked to do other kind of maybe administrative work, right, or customer service work when all you were previously doing was sales. This is something actually we see quite a lot of. That would also trigger a constructive dismissal or trigger you as an employee to have the right to say thanks but no thanks. That's not what I was hired to do here. All right, we'll do some rapid fire questions here, guys, because we've got about 5 minutes left and we've got quite a few questions. Thank you so much. I will get to them all, I promise, even if we have to go a couple of minutes over time. Terry is up next. Terry says hello from Alberta. Terry says he was laid off. If the old employer was called about my past performance, can they comment, or is that confidential? Terry, they can comment as long as what they say is true. That is the measure, that is the marker of what an employer can or cannot say. They have to answer honestly, and they cannot lie effectively, even if within the realm of lying is maybe exaggeration. That is something that a previous employer could do. Our courts have said that in Ontario in particular, but across the country as well. So yes, an employer can ask about previous performance, and as long as your former employer isn't lying, then there's nothing necessarily that could be done in the circumstances. Terry, if you've been let go or laid off from your job, make sure you were offered the correct amount of severance. Even if this happened a few weeks or a few months ago, use our severance pay calculator, but by all means, it applies to Alberta employees as well. Make sure you were offered what you were actually owed. By the way, as part of severance negotiations, oftentimes we can negotiate a letter of reference, or we can negotiate an employment letter confirming what a previous employer will and will not say about the employee. So if you're worried about your reputation with your previous employer, that can be part of a severance negotiation as well. It's something we do literally with every single severance negotiation. We want to make sure that your reputation remains intact when it comes to your previous employment, so that you'll have an easier time finding that new employment. All right, next question is from Elisa Mack. I'm in a sales position. The manager hasn't liked me there for 4 years, has bullied me. 2 weeks ago, she hired her friend to replace me and sent me to a slower store. Elisa, this may very well be a constructive dismissal. And by that, I mean, if your manager has now sent you to a slower store, and if you're in sales, what that might mean is lesser income for you, whether it's lesser commissions or lesser bonuses, etc. And that's going to mean a significant change to your compensation. I mean, that is the definition of a constructive dismissal. So don't let too much time pass. Elisa, if this has just happened, you want to have a chat right away. Don't wait 3, 4, 5, 6, 7, 8 months and then take issue with it. It might be too late. When we're talking about changes to your employment, you have to take action as an employee as soon as that change happens. The longer you wait, the more difficult it becomes to undo the harm that has been done through that change. So Lisa, give us a call at the office. Again, if this change is going to affect your income, right, because it's a slower store, that is going to likely be a constructive dismissal if it's a significant change to your income. All right, Aubry asks, been working on salary for the last 3 years. Employers saying they want to switch to annual contracts and switch staffs to contract positions. What should we do about it? Interesting question, Aubry. The first thing is employees that are signing successive multiple contracts year to year, listen, they're going to be treated the same way that indefinite employees are, employees that have just signed one contract and have just carried on without signing new contracts year to year. So while it's something that we want to deal with, Aubry, I'm not overly concerned about an employee signing successive contracts. because they have the same rights that any other employee would have. That said, Aubrey, again, what's in the contract is going to matter. I wouldn't be surprised if they're presenting you with these new contracts, even though they're now annual contracts, that there will be termination language in the contract that tries to limit your severance, that tries to give the employer rights that they probably don't have right now. So before you sign, Aubrey, whether it's a 1-year contract or a contract that's supposed to be indefinite, right? Before you sign, please, please, please give us a call at the office. I guarantee you that the contracts have some things in it that you're going to want out or you're going to want changed. All right, a few more questions here. Ron asks, employer trying to force me into a new position so that he can hire a family member. Another quite common theme, unfortunately, that we hear, particularly in smaller, medium-sized businesses. I've been working as a manager and they want to move me to sales and cut my salary. Can I stop this? Ron, if you're in British Columbia, Alberta, or Ontario, absolutely you can stop this. It sounds like the very definition of a constructive dismissal, demoting you and cutting your salary. There can be no clearer constructive dismissal than that. Ron, please, before you respond to your employer, before you say, Alex told me this is a constructive dismissal, let's chat strategy. Let's chat. How do you respond to your employer? What do you say and what do you not say before you get into that conversation? Please give us a call at the office. Don't let this pass without taking a stance and without speaking to us first. I mean, this is exactly what our employment laws are meant to do, to protect employees in exactly that kind of situation. All right, next up in line is Paul on YouTube. Paul asks, what are my rights of using my personal phone for work-related tasks? They want me to sign in a tracking app of my hours on the job, and I did not sign a contract. Is that breach of my personal privacy? Listen, Paul, it's not outside the realm of what an employer can do to say if they want you to use a particular cell phone, if they want you to use a particular laptop where you have to log in and where they can track that information. It's not illegal. Paul, actually, lots of employers do that nowadays, particularly employers where some employees are working from home, etc. As long as those rules are clearly communicated and you know how they're tracking you and when they're tracking you, and I'm talking about a company cell phone here or a company laptop, that's not illegal. It's not a breach of your privacy rights. What may very well be a breach of an employee's privacy rights, however, is if they're tracking you on your personal time. Right? So if you have a cell phone that you use for both work and personal use, they cannot track your personal use outside of work hours, right? They can't track you on your break or on your lunch, right? Or on the weekends if you're not supposed to be working on the weekends, if you've got a Monday to Friday 9 to 5 job. That's where the line is when it comes to privacy rights and tracking employees in the workplace. We will have to leave it there, folks. Thank you for all of you who have posted your questions. If I didn't get to the last couple of questions, and I apologize, we ran out of time. Don't worry. Join us tomorrow for another live stream. The information's on the screen right now. Go ahead and post your question again then and there, and I promise it will get answered. Thank you, all of you, so much for viewing this segment and listening in. Thank you for for those of you that have posted your questions. I have no doubt you're now much better placed as an employee in order to protect your rights and entitlements. Have yourselves a great rest of the week. Have yourselves a great weekend. Until next time, everyone, thank you so much again, and take care. Bye-bye.